by all means.
Thank you very much, Mia, and thank you. Thanks to all participants for joining on the conversation, and I look forward to discussing with you any questions that you may have. I will use during my presentation, I will use a PowerPoint, so I will share screen in order to perhaps render some of the text that we'll be alluding to more accessible for the non-lawyers in the group. Right, can you see this, Mia, before I go? Okay, all systems are go. So we will be discussing the application of human rights to international armed conflicts. It's perhaps worth starting with the observation that today this seems as if this is quite a straightforward idea, that human rights continue to apply in all circumstances, protecting all victims everywhere at all times. But this is not how things were perceived up until 30 years ago. And let me perhaps go through some of the main stages by which international human rights law became applicable to armed conflicts, or the acceptance of the proposition that international human rights law is applicable to armed conflicts became more widespread. And we will be discussing some of the tensions that in the past prevented its application, but still even today hamper or complicate the application of human rights law. So when we are talking
Yuval,
about...
Sorry, just a second. Do you mind making the presentation full screen?
Yes, sure.
Please.
Is it better?
Thank you. Yes, thanks.
Okay, so in the beginning of when we're talking about law and war, we were not talking first about human rights law. I mean, we were talking about another branch of international law, which Mia mentioned in her opening remarks, and that is the laws of war, or international humanitarian law, which is a IHL in abbreviation, which is a body of law that developed in international relations around the mid-19th century, around the Crimea conflict, which is still a hotspot of international violence. That body of law, its creation has been greatly, significantly facilitated and aided by civil society, by an organization that was created around the same time, which we now call the International Committee of the Red Cross. The idea was to introduce to wars, which at that time were lawful under international law. They were still not prohibited. They were a reality. And the idea was that if we cannot actually prevent wars, and if wars are a reality for human societies, the least that we can do as human beings, as humanitarians, is to try to find ways to mitigate the harm and suffering that is caused during wars or armed conflicts. And what we see today as IHL is really a body of law that revolves around four major principles. One is the principle of necessity, and that is that attacks must serve only a military purpose. They cannot be gratuitous. They cannot be punitive. They have to serve a concrete military purpose. The principle of distinction between military targets and civilian targets, as well as between combatants and non-combatants. The principle of proportionality, that requires that even in cases where there is a conflation of civilians and combatants in the same area, the attack could go forward only if the harm to civilians is not excessive in nature, in comparison to the military advantage that could be obtained. And the principle of humanity, that focuses on the need to prevent superfluous injury, unnecessary suffering, but also provide civilians with humanitarian aid and the like. Now, IHL has been conceived initially as something which would be applied primarily by the states themselves that are involved in armed conflicts through their militaries, Militaries have military law, they have disciplinary military discipline, and in extreme cases, violations of the laws of war would go to civilian courts, namely either to the criminal courts of the state whose soldiers committed the atrocities, or to the in the case that where a party has lost the war, it could be that the other party's domestic courts will try the war criminals. What we have seen after World War II is an increased interest in actually internationalizing the enforcement of those extreme violations. And we now have a regime under the Geneva Conventions where grave breaches and now also serious violations of IHL could be enforced either by international courts or by any court in the world, any domestic court exercising what we call universal jurisdiction. By contrast, IHRL, the International Human Rights Law, is a body of norms that was created almost a century later, after World War II, through instruments such as the Universal Declaration of Human Rights from 1948, which René Cassin was actually very well part of the drafters. He was instrumental in formulating that treaty. There have been subsequently other important treaties, such as the ICCPR, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. These norms are enforced either by domestic courts or by international courts and committees, such as the European System of Human Rights, which René Cassin also participated in, the Human Rights Committee of the UN, which I worked on with, and other, in some cases, some of these rights could also be enforced by the International Court of Justice. It's important to emphasize that the ethos of international human rights law is different from IHL. It's not about mitigating harm. It's really about protecting universal human rights, restricting abuse of state power, and effectively protecting victims. So there is a much stronger protective orientation to IHRL than to IHL. Both bodies of law, however, I should say, do suffer from some common problems. There are serious enforcement issues, both with regard to human rights law and IHL. This is partly because international judicial bodies in many contexts do not have jurisdiction over violations of IHL or IHRL, whereas third parties, third states could enforce those bodies of law because many of the laws that we have in both branches are couched in multilateral treaties, which states can theoretically enforce, all states that are parties to these treaties. We have seen up until recently significant reluctance on the part of states to actually bring forward legal proceedings in cases that do not directly involve their interest. And domestic enforcement of human rights law and IHL has been quite weak over the years. States do not like, generally speaking, to try their own soldiers. And with the rise of populism and backlash against judicial activism, we are seeing in several parts around the world even greater reluctance than before to apply international or foreign standards in ways that curb the opportunities or the possibilities that governments have. And I think we are seeing, at least in an IHRL context, a crisis also in this country concerning the applicability of human rights in domestic courts. So IHL and IHRL developed in different points in time. They have different ethoi. They were drafted, I should say, by different groups. The IHL is very much, although the ICRC, the Red Cross, was quite important. Many of the drafters of documents such as the Geneva Conventions were military personnel. So these treaties were very much oriented also towards military necessity, whereas with regard to human rights law, many of the treaties were drafted by human rights lawyers, by constitutional law experts who also had experience within domestic legal systems. The orientation of the treaties was different in the sense that one treaty was providing rights to individuals. This is human rights law, whereas IHL was effectively providing mostly rights to states and to militaries, one against the other. Very significantly for our discussion, human rights law was very much focused on events taking place inside the state, whereas IHL was very much concerned about wars which take place, at least in part, outside the territory of the state. So they also had different geographical focus. And up until the mid-1990s, the dominant approach was that the laws of war regulate situations of war, whereas human rights laws apply with regard to times of peace. So in traditional international law had a sharp distinction between the laws of war and the laws of peace. IHL belonged to the laws of war, human rights to the laws of peace. Now, this has started to change. This equilibrium has started to change in the post-World War II era. And there have been a number of developments which have facilitated this change. One is the gradual introduction of human rights ideas into IHL. So the Geneva Conventions are much more human rights oriented than the previous laws that had been on the books. And in 1977, there has been a revision of the Geneva Conventions, and more human rights found their ways into IHL. At the same time, IHL became more and more interested in what are called NIACs, which are non-international armed conflicts, including civil wars. So this distinction between one body of law applying externally and one body of law applying internally became much more blurred. At the same time, human rights law have become more and more applicable also in extraterritorial context. That is, when a state is acting outside its territory, for instance, when it is occupying the territory of another state. And the emergence of international criminal law, as we will see, was also important because bodies such as the International Criminal Court enforce both human rights law and also international humanitarian law. And in effect, it is supporting, one could say, the merger of these two bodies of law. Now, this status quo where human rights apply in times of peace and IHL applies in times of war, effectively was rejected as a matter of international law doctrine in 1996, when the International Court of Justice delivered a very important advisory opinion, a non-binding decision, but nonetheless very influential on the question of whether the use or threat of use of nuclear weapons violates international law. It has been argued actually by the UK that the court shouldn't be reviewing the legality of nuclear weapons under human rights law, because this is a matter that is exclusively regulated by IHL. But the court rejected this and actually says, no, human rights law continues to apply in times of peace and in times of war. And as a result, we are competent. We have the capacity to review also the legality of the use or threat of use of nuclear weapons under human rights law. However, the court said, since the norms of IHL are more specific, are more closely tailored to deal with questions relating to the legality of all sorts of weapon systems, we are going to give, whenever there is a clash between these two bodies of law, we are going to give the right of way to IHL. This is called in legalese lex specialis. So the special law would be given the right of way, and that also has some interpretive consequences, because it would mean that we would try to interpret human rights treaties in line with the provisions of IHL. This has been affirmed also by this holding by the next big advisory opinion of the International Court of Justice on the Israeli wall in the occupied territories, where again Israel argued this is the question of whether we can construct a wall is only a question of IHL, but the court said no, this is IHL, but we would also look at the human rights dimensions of this case. And actually the human rights dimensions of the case were very important because there is, for instance, a human right not to have one's movement restricted. This is the freedom of movement. This is a right that is not given explicit expression in IHL, but it is given an explicit expression in human rights law. And the court says, I have the capacity on the basis of the nuclear weapons case to apply this here again. And the same approach was taken later on by other bodies, such as the European Court of Human Rights. The European Court of Human Rights, although initially it had some difficulties in how to manage the application of human rights and IHL at the same time, because the court is only formally authorized to apply human rights. It is not authorized to apply IHL. So it has to read in the provisions of IHL into human rights law by way of interpretation. But eventually it found all sorts of interpretive techniques, either to read in the application of IHL into human rights law. And the case on the screen is a case involving the UK activities in Iraq and the detention of enemy combatants in the Iraqi context without a basis under human rights law, but with a basis under IHL. And the court said this could be sufficiently acceptable. In other cases, I'm going to skip one of them, but in a more recent case, the court did try to deal with this interplay between human rights and IHL in the Georgia versus Russia case, a case dealing with the 2008 war in Georgia, where the court held, well, initially, human rights law cannot apply when we are in the first days of war and the situation is chaotic. Under those conditions, it would be impossible to identify who actually controls the situation on the ground. But later on, we will apply human rights law and also deal with the consequences of that application. That I should say that holding has been recently challenged by another case involving the war in Ukraine. And we will see how the court eventually determines this equilibrium between human rights law and IHRL. The Human Rights Committee, which I sat on, adopted a similar approach. This is a document that it published in 2018. It's called the General Comment on the Right to Life, where it explained how the two bodies of law would operate side by side in situations of armed conflict. Essentially, what the court says here, what the committee says here, that when a state is violating its obligations under IHL, in cases involving deprivations of lives, in questions involving the killing of human beings, then it is also, by necessary implication, would be regarded as if it is violating also its obligations under human rights law. So in a way, the committee here accepted the approach of the International Court of Justice in the nuclear opinion test and said the nuclear weapons opinion, and it said that whenever a state would be following IHL, it would have a presumption that it is not violating IHRL and vice versa. We will read IHL as being legally dominant in situations involving armed conflict. Interestingly enough, the committee said another thing which is quite significant, and that is that we will apply the same construction not only to the question of whether a state is violating the laws of war in the sense that it is violating the principles of IHL, which I mentioned, but we could also apply the same construction with regard to the violation of what is called the jus ad bellum, namely the prohibition against going to war in the first place, and an invasion or an act of aggression that violates the UN Charter and leads to deprivation of lives could be regarded or would be regarded also as by necessary implication entailing violations of human rights law. So we are seeing not only merger of IHL and human rights law in the case law of international human rights bodies, but also a merger of the laws on the use of force and the laws of human rights law. In the interest of time, I will skip this slide and let me bring it to close by speaking briefly about how this merger presents itself in the case of the war in Ukraine and the war in Gaza, and then a few final observations, and I will then be happy to take questions that you may have. So with regard to the war in Ukraine, we have seen a very extensive involvement of human rights bodies in reviewing various aspects of the war. That includes the European Court of Human Rights, which is hearing cases brought by Ukraine and also by Netherlands with respect to the downing of the plane, of the Malaysian plane over Ukraine allegedly by Russia. So we are seeing human rights bodies that are looking at violations of IHRL and are using in the review an analysis also of IHL. So to the extent that Russia has been found, for instance, by a Human Rights Council Commission of Inquiry to be in violation of IHL in engaging in this indiscriminate attacks, in rape and other sexual offenses, in torture of detainees and the like, this would translate itself also to violations of international human rights law, and therefore human rights bodies could review these violations and also present their views on the violation, and that could, in the case of the European Court of Human Rights, could actually lead to a binding judgment. In the case of the Human Rights Council, it would lead to resolutions that may have some political impact and could maybe motivate some other countries to apply sanctions or to initiate domestic proceedings against Russian officials. We have also seen in the case of the war in Ukraine, the ICC, so far, well, investigating a variety of issues, but so far issuing arrest warrants against two Russian officials, Putin and the Child Rights Commissioner, Maria Lvova-Belova, with regard to transfer of children, which is seen from Ukraine to Russia, which is seen as a violation of IHL, but also as a human rights violation. This has been so far litigated as a war crime. We have seen the ICJ express itself on a human right regarding the treatment of the Ukrainian population in occupied Crimea and their education rights, where the ICJ had held very recently, a few weeks ago, that Russia had violated the minority rights of the Ukrainians in Crimea. And finally, in that regard, we are seeing on the table proposals for a special tribunal on aggression, which we could discuss later in the Q&A. This is an idea which both has, of course, a criminal law dimension. In Nuremberg, we have seen prosecutions and convictions on the crime of aggression. At the time, it was called crime against peace. But according to the analysis I offered before, this could also involve a human rights violation. The act of aggression and the resulting loss of life could be analyzed also as a human rights violation. Moving on to very briefly to the war in Gaza, we are seeing the same tendency to apply both human rights law and IHL to the same conflict, and relying heavily on the fact that IHL had been violated in order to authorize human rights bodies to review and to issue findings on the different violations that have occurred under human rights law. So we have seen a very large number of human rights special procedures, and the Human Rights High Commissioner expressed their views on violations which both sides to the conflict have undertaken, starting from the October 7 massacre and hostage-taking by Hamas, and then moving on to criticize Israel for what has been described by these bodies as indiscriminate bombing, unsafe evacuation of civilians, or deportation, blocking of international aid, untenable humanitarian conditions, attacks on hospitals, and the like. The idea here is that all of these measures constitute a violation of IHL, but by virtue of the relationship between IHL and human rights law, they are being also understood as human rights violations, and thus they fall within the purview of human rights mechanisms. We've also seen, like in the Russia case, ICC introduce itself into the conflict in real time. The prosecutor has a pending investigation and has already announced that it will review both Hamas crimes and Israeli violations under this heading of either crimes against humanity or war crimes. Crimes against humanity typically applies to covers both IHL and human rights violations. War crimes apply to IHL violations, but these IHL violations could also be analyzed as human rights violations. And finally, of course, the genocide case brought by South Africa against Israel. Again, the use of a criminal law instrument, the Genocide Convention, in order to bring to the forefront alleged violations both of IHL and of human rights law. So final takeaways that I would offer to you before we engage in a discussion. We are seeing growing acceptance of the relevance both of human rights law and the jurisdiction of human rights bodies in armed conflicts. We are seeing the increased role that international criminal law plays in this as an enforcement machinery, both for human rights law and for IHL. We are also seeing some movement towards treating unlawful use of force, either aggression, or in the case of Israel, we are increasingly seeing calls on Israel to stop its disproportionate use of force being configured as a human rights issue. What we are still seeing, despite all the developments that we have chronicled, we are still seeing problems of under-enforcement of IHL and IHRL. So the ICJ, for instance, could be instrumentalized only on very narrow jurisdictional basis, which sometimes lead to choice by parties of treaties that wouldn't necessarily deal with the crux of the matter. So one could make this argument both with regard to the case involving Russia, where one dealt with racial discrimination, which is probably not the most dramatic issue in the case of the Russian war against Ukraine. And in the South Africa-Israel proceedings against, certainly Israel believes that genocide is not the proper framework to deal with this issue. But if there are issues, there are probably more better dealt with as IHL issues. The ICC could serve as an important safeguard, both with regard to IHL and IHRL, but here we have significant limitations on its jurisdiction. For instance, the ICC cannot deal with aggression. So with regard to aggression, one has to reinvent the wheel and create a separate tribunal for aggression. And even with regard to the crimes that it can deal with, it has serious material capacity limitations. So the ability to actually enforce both human rights law and IHL still remains quite limited, which could explain why we are still seeing many violations and alleged violations in contemporary conflicts, including the two I mentioned in my remarks. So I will stop here, and I look forward to dealing with any questions that you may have.
Thank you very much, Yuval. I did mention it in the introduction, but Yuval was actually my professor at the Hebrew University 23 years ago. So this really threw me back to those times, but really, really fascinating. We do have a first question, but from Tom. So putting aside the accusations of genocide, which are raised at the ICJ at the moment and are being debated, do lesser offenses of human rights violations apply to both the Israeli military and Hamas perpetrators, terrorists, over the abuse and capture of hostages, indiscriminate attacks against citizens? What is the measure of these two mechanisms, IHL and international human rights law, in holding to account these two factors, I think?
Yeah, thank you. So with regard to IHL and human rights law, it's maybe the first thing which is important to note that both bodies of law are not based on the idea of reciprocity. So one's obligations under human rights law and also one's obligations under IHL are not, by and large, are not dependent on the fact, on the question whether the other party to the conflict has complied with its own obligations. So this is actually important to note, because there are some areas in international law, such as trade law, where actually relations are reciprocal, and a violation of a trade rule by one country could lead to trade sanctions by another country. This is not the case with humanitarian law, because the philosophy here is that the ultimate beneficiary or the ultimate right holder of the rule is the individual, is the person, the victim, who is actually being protected. Having said that, I mean, we do have now within IHL quite an established body of norms, which would apply IHL to states, but also to non-state actors, to organized armed groups, such as Hamas. So there would clearly be many rules of international law, not all rules, but many rules of international humanitarian law that would be applicable to Hamas. Certainly killing civilians or taking civilians or even military as hostages would be a violation of these rules. And the examples provided with regard to indiscriminate attacks, etc., would of course also apply both to Hamas, but also to Israel. With regard to human rights law, this is a bit more tricky. The human rights treaties are treaties that have been signed and ratified by states. They are designed to, initially, human rights law was an extension of domestic constitutional law. They were designed to curb the power of states, so that states do not use their power in an abusive or arbitrary fashion. We are seeing, however, in the last 20, 30 years, increased willingness by international bodies, such as the Human Rights Council, also to apply at least based of human rights law to non-state abuses. But with regard, for instance, to ISIS, we have seen quite strong language that was adopted by international human rights law bodies that was critical of these abuses. With regard to International Criminal Court, as I said before, the ICC could exercise jurisdiction over war crimes, but also over crimes against humanity, and that is not limited to crimes against humanity perpetrated by states. It would also encompass crimes against humanity perpetrated by a non-state actor. So the leaders or the actual commanders of that non-state actors could also be held criminally accountable.
Thank you. Thank you, Yuval. Second question, what is the mechanism for keeping a record of violations by each side while armed conflict is still unfolding?
Yeah, that's an excellent question. So effectively, a military is required to not only, well, military commanders are required under IHL not only to not commit crimes, but also to suppress crimes that are committed by their persons under their command. by the soldiers who are accountable to them. And that requires also investigating allegations of crimes, and also investigating situations where there is a reason to believe that a serious violation has taken place. So the parties are under an obligation to investigate, and that investigation also includes, by necessary implication, the duty to collect information. We do not have, at this point in time, very clear international standards on collection of information outside the context of allegations or reasonable grounds to believe that a violation had occurred, although that is certainly a good practice. I know that certain militaries, including the IDF, do tend to chronicle many of their activities. But then we do hit another roadblock, and that is the question of transparency, and that is the question who actually has access to that information. Now, on the other side of the conflict in Gaza, or maybe also this is true for the Ukraine war, there is indeed a problem. What do you do when one of the parties is not actually adhering to the law, doesn't consider itself bound to the law, doesn't really chronicle or even investigate allegations? And there are other groups, third parties have a very important role to play. So international fact-finding bodies play a role in collecting evidence. Many civil society groups are playing a role. There is increased involvement of NGOs that have expertise in collecting and preserving digital evidence, and in actually using sophisticated software in order to map violations and understand better what has been unfolding in a certain battleground or in a certain crime zone. But this is indeed the question of accountability and transparency are indeed very serious problems still in armed conflicts.
Thank you, Yuval. The next question is from Sheldon. Is current international humanitarian law, and I guess as it stands on its own, adequate to deal with the non-state entities like Hamas, which breach many of its rules, including preventing evacuation of civilians, hiding in schools, and the complicity of third aid agencies in these actions?
Well, I mean, the question here is not so much, I think, whether IHL is adequate, because IHL, like I said, does impose obligations also on the non-state actors. So the non-state actors cannot act indiscriminately. It cannot target civilians. It cannot take hostages. It cannot, of course, shoot its own civilians. It cannot hijack humanitarian aid. The problem is really not with the law. The problem is with the implementation of the law. We don't have good systems to enforce the law on non-state actors, partly because these non-state actors do not have legal systems to fall back on. And in terms of the ability to generate real deterrence against these actors, it is often much, I mean, the leverages that one has with regard to such organizations are often much less significant than one sees with regard to a state, because a state, you do have, on the state side, you do have officials who want to travel or do travel around the world. And they want to basically do this with an aura of legitimacy. But if you are already designated by many countries around the world as a terrorist group, and you're already I mean, your ability to travel around the world and claim to have some legitimacy is already been seriously compromised. You might have less to lose from the threat, the increased threat of now also being prosecuted at the ICC or at the domestic court of another country. So there is certainly here a certain asymmetry. Now, some say that asymmetry in legal obligations is a mirror image of the asymmetry that one has in terms of of military capacity, that the state has much more military capacity, and the legal obligations are actually proportionate to the military capacity that one has. But I mean, many states are actually quite concerned about the ability to fight within the existing rules. An enemy that chronically violates the rules does not really maintain a principle of distinction. Israel, for instance, argues that Hamas strategically places command posts under hospitals. I mean, as you know, this has been contested to some extent to how central these command posts are. But I think there is little doubt that there has been some blending of military activity in civilian locations, and that really creates a real challenge in how do you actually fight while also implementing your own obligations to protect civilians, to accord special protection to places like hospitals. There may, I mean, in the end, if there are no other solutions that will be found to these sort of dilemmas, states would be pushing for at least for a reinterpretation of their obligations, and maybe what we are already seeing in Gaza in terms of the very large number of Palestinian casualties could also be understood as some reinterpretation by Israel of what is the principle of proportionality, which is already quite I should say, an open-ended principle which different militaries apply in very different ways. So this imbalance is actually a problem. IHL does provide certain solutions, but I wouldn't say that these solutions are very satisfactory and sufficiently mitigate harm, and they do not sufficiently protect victims at the end of the day.
Thank you. And I guess that's where the international human rights law comes in, as trying to fix somewhat of that imbalance.
But in a way, internationally, human rights law does afford some protection, does cover some of the areas which IHL does not reach. The problem that states that are engaged in warfare have with human rights law is that human rights law was mostly designed to deal to regulate states under conditions of peace, and therefore there are states maintain, I mean, this body of law, we would try to implement it in a residual manner to fill some gaps, such as freedom of movement in occupied territories, but it was not really developed, or it's not sufficiently closely tailored to the challenges of a military force in a very intense battlefield environment. So there are questions regarding how fit for purpose is human rights law for very specific operational challenges, where IHL has really been developed to deal specifically with these operational challenges.
Thank you, Yuval. Another question from Tom. Please, could you shed any light on the relevance of the similarity or distinction between ISIS and Hamas as terrorist groups, or armed forces, bearing in mind that Hamas represents the elected government by the citizens of Gaza, even though it's not an independent state?
Yeah, so I think there are some, I mean, by and large, IHL doesn't draw sharp distinctions between rebels, terror organizations, other forms of armed militias. IHL does try to deal with these questions of how do you apply organized violence in a military conflict, while being agnostic of the rightness of the cause. Which is because, as I explained before, it started at an era where wars were still lawful. So it is at some level agnostic about who is the party, where is it coming from, whether it was elected or not elected, etc. So I would say that on a tactical level, there wouldn't be that, the difference would not be very significant. I think there is significant difference when you come to the question, when it comes to the question of designating who are combatants. And here, when you have an organization like Hamas that is not only a military power, but has also been the governing authority in Gaza for the last 17 years, I think you do have some significant problems in delineating where does the military stop, where does the military wing stop, or the designation of combatants who can be targeted and killed during a conflict. And when are we talking about officials, government officials, so to speak, who are basically protected from being designated as combatants and therefore cannot be targeted if they're not taking direct part in hostilities. And here I think this is somewhat different from the situation of ISIS, which ISIS simply didn't have enough time to base itself as a more or less functioning government in the places that it took over. So this is certainly a complication. Another complication, of course, has to do with the legitimacy of Palestinian self-rule, which is, of course, much more accepted in the international arena than the idea of ISIS self-rule. ISIS was not considered by any state as a legitimate political authority. With regard to the Palestinian territories, while Hamas is not regarded as a legitimate authority, Israel certainly is not regarded by most countries as having a justified claim to actually control those areas, and that also affects the balance that also affects the analysis of the legality of different of the activity of the operations of both parties. We do hear I think extreme. I would disagree with those arguments, but we do hear extreme positions that Hamas is exercising powers of lawful resistance, and therefore this is how we should analyze the conflict, and Israel is really not the victim, but effectively the aggressor. These sort of arguments were not raised with regard to ISIS. So I think the context, the political context also affects the types of arguments that are being raised in international discourse about the war.
Thank you, Yuval. I wanted to ask you, before we move on to another question, on the special tribunal on the crime of aggression against Ukraine. And if an international tribunal is set up and it's designed to go for the big, the top of the pyramid, which is Putin and his immediate group, what enforceability mechanism does it really have if it can't get hold of Putin?
Well, I mean, the idea of having an ad hoc international tribunal is an idea which we have seen already play out in the Yugoslav civil war, where the UN has established, the Security Council established an ad hoc tribunal for the former Yugoslavia, also established an international tribunal for Rwanda. And those international tribunals did exercise jurisdiction, not over aggression, over war crimes, genocide, crimes against humanity, but with respect to the top people in those countries. So Milosevic, the president of Yugoslavia, was put on trial, as was the prime minister of Rwanda. Effectively, these bodies do have the power of jurisdiction. There are no immunities in international law with vis-a-vis an international tribunal. And therefore, if there is international support for establishing a tribunal for aggression, then theoretically they could go after Putin for aggression as well as for the very inner circle. Actually executing arrest warrants is, as we see also with the ICC, is of course much more difficult, because you would need to basically find ways for countries to extradite those individuals. So Yugoslavia was under a lot of pressure, and eventually it extradited only after there was political transition. They extradited Milosevic to The Hague. In Rwanda, there was also political transition at the end of the war, so there was no there was no problem in that regard. But where we have not seen political transition, the likelihood of extradition is significantly lower. Now, part of the debate, I mean, the likelihood that we will have an international tribunal set up by the Security Council, of course, with regard to Russia is zero, because Russia does exercise the right of veto. So this is really the conundrum. How do you then square the circle? How do you create a tribunal which would be international enough so it could issue these arrest warrants against the top leaders, but yet would have enough support, international support, to be credible? And this is, of course, this is why, in a way, the process has been stuck now for almost 2 years, because this initiative to create a tribunal was introduced very shortly after the war broke out. The alternative option, which is to create some hybrid tribunal within Ukraine. Ukraine does have on the books a law against aggression, and we have seen models by which countries establish a special court within their legal system, which has its own complications, but it is doable, and then add foreign judges to sit on these courts, on these trials, to give more legitimacy to the process. But then it is, I mean, most experts would argue that an arrest warrant that would be issued by such a tribunal wouldn't be able to circumvent the immunity of head of state and the troika that surrounds the head of state. So a Ukraine tribunal would not be able probably to, even if it's a hybrid one, would probably not be able to generate a binding arrest warrant against Putin, which would be honored by other countries around the world.
Thank you. A question from Claire. The IDF gives warning of where in Gaza it's going to strike. So Gazans in the north were moved to the southern area and Rafah. Most countries say this movement of civilians has been forced and not voluntary. What should armies do to protect civilians if their movement is said to be forced and not in order to protect them?
Yeah, so this is a very difficult question, which deals with a very contested aspect of the Gaza war. So effectively, what you have under the IHL, like I said, one of the principles that is being okay, maybe I should have said this more clearly, but there is a principle of distinction. You have to distinguish between civilians and combatants, and between civilian targets and military targets. And one way by which militaries are legally required to implement this duty of distinction is through what are called precautionary obligations, which include early warnings. So before you are targeting, for instance, a house in which a high-level enemy combatant is put up camp, but there are also civilians in the house, you should do whatever you can to basically evacuate the civilians, to give them warning before you actually you execute the attack. And the IDF, actually, this is something that the IDF typically does, provide these early warnings, does these phone calls, and like you said, I mean, has leaflets to advise individuals that they will operate here. And therefore they should get out of harm's way. And they did it also with regard to the operation in northern Gaza. I think what was unique here is the scale of the warning. So the warning was not tactical, that they were going to attack this block of houses or even this neighborhood in this town or village, but rather they said all civilians in the north should head south. So that was quite a dramatic warning. Now, the IDF says, and I think with some degree of justification, this was actually a measure that was designed to remove as many civilians as possible from harm's way. I think the criticism that has been raised, and Israel has some answers, although I'm not sure that it has all the answers, is, well, first, the movement from one area to another is in itself dangerous, and we did hear of civilians who were harmed on the way, and both parties are actually blaming each other for harming the civilians on the road. But also that the areas to which they were evacuated were areas which were not completely safe. There were also areas where there have been hostilities, maybe not at the same level of intensity, but over time we are seeing that the campaign is moving from the north to the south. So the civilians that evacuated the north are finding themselves now in the south, actually to some extent closer to the hostilities than the people who are left in the north. So the dynamic nature of the conflict also casts doubt on how effective in the long run these evacuations are. There are also questions about humanitarian aid and provisions to people who have been evacuated. So I wouldn't say that the general idea of warning individuals, we are going to operate here, is wrong. I think this is actually something that, at least in the short term, might have saved lives. But I think the concern is about if you are going to engage in something like this, you also have to you have to try to ascertain that they will be more or less safe in the area to which they arrive, and that they will have humanitarian provisions there. And this is, I think, an area, this is an aspect of the operation for which Israel was criticized.
Thank you, Yuval. And we're running out of time. So firstly, thank you again for the presentation and taking on the questions and having that sharing of information. Thank you for our participants who joined us this evening. René Cassin runs a series of events. It's available on our newsletter, so please do sign up. You will send you a link. It's 137 days since the war in Gaza. It's 2 years in Saturday since the war in Ukraine. And there are 108 more conflicts happening around the world. And I think if there's anything we can take from the session today is that we've got the mechanisms, we've got the frameworks, we've got the standards, we've got the principles. I think what we need now is just to make sure that they're applied, and where at the end of the day, the humanity and the individual are at the center of decisions and actions that are taken. So Yuval, thank you very much again.
Thank you very much.
Bye-bye, everyone.